Firm of Tarlow, Breed, Hart and Rogers, and my first question is, why isn't the Furman name on this list?
Great question. Joel, nice to be with you. Jeffrey, always a pleasure.
Yes, Mark. Mark, business never stops, and that means the law never stops. So what's the big story today?
So wanted to talk about another wage and hour independent contractor employee case. We've talked about a bunch of them over the last few years, and it's basically impossible in Massachusetts to employ an independent contractor. And there are literally scores of class action lawsuits against restaurants, resorts, golf clubs, all sorts of businesses that employ folks as independent contractors. And Massachusetts has the most strict law of any state in the United States. It has a much more strict law than the United States has when it comes to the tax code, Social Security, labor issues. So basically, the rule in Massachusetts is I can never, in my law firm, employ a lawyer as an independent contractor.
But you could hire a group of lawyers on a project basis through an employment lawyer service.
They would be employees of the employment service.
But then they would
They
be
would
let
not
go.
be,
Afterwards.
there's some of those cases too. It's very complicated. The traditional test is whether you actually have a right to control folks. So let's say a guy works for 20 different law firms on a project-by-project basis. If he controls how the work gets done, he's an independent contractor under most states' law, but not Massachusetts. So I always talk about how people don't know what they're signing. Oh, just give me an employment agreement, just a boilerplate agreement. Well, here's a company, a Massachusetts company with a boilerplate agreement that employs drivers who live and work in New York. Not even in Massachusetts, but it is a Massachusetts
I
company.
I bet you they're not unionized too then.
That's true, but so the agreement, the boilerplate, says all rights of the parties are determined under Massachusetts law. Company thinks that, boilerplate, or the lawyer thinks boilerplate, want to have our home field law apply. Well, the company doesn't realize that what they're doing is they're walking into enormous liability because these folks are employees under Massachusetts law when they would be considered, in all likelihood, independent contractors under New York law. So what are the implications? We have incredibly strict wage and hour laws that have to be complied with. Independent contractors don't have those rights. You agree on an hourly rate, you pay them, you're safe. But if you fall within the clutches of the Massachusetts wage and hour law, you are walking into enormous liability. I hope these folks have insurance coverage to protect this, but they're defending a class action, and they tried to get the case, the defendant tried to get the case thrown out, and it was rejected unanimously by our Supreme Judicial Court. This was a company engaged in the business of delivering packages in various states along the East Coast, including Massachusetts and New York. So the point is, the company unknowingly walked into this enormous liability. They had no idea that what they were doing was unlawful. They could reasonably think that how could New York drivers possibly be subjected to Massachusetts law in terms of their wages? But